Hi, I'm Jeffrey Anderson from Ohio University's College of Business. In the United States, the relationship between the employer and the employee is highly regulated. In this brief video, we'll outline some of the major employment laws in the United States. After watching this video, you should understand the role of the Equal Employment Opportunity Commission, be able to discuss some of the laws related to employment discrimination, and identify two forms of sexual harassment. The U.S. Equal Employment Opportunity Commission, or EEOC, is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of that person's race, color, religion, sex, national origin, age, disability, or genetic information. It is also illegal to discriminate against a person because the person complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. Most employers with at least 15 employees are covered by EEOC laws. The laws apply to all types of work situations, including hiring, firing, promotions, harassment, training, wages, and benefits. Let's review some of the laws that the EEOC enforces. The cornerstone of employment law is Title VII of the Civil Rights Act of 1964. This law makes it illegal to discriminate against someone on the basis of race, color, religion, national origin, or sex. The Pregnancy Discrimination Act was an amendment to Title VII, making it illegal to discriminate against a woman because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. The Equal Pay Act of 1963 makes it illegal to pay different wages to men and women if they perform equal work in the same workplace. The Age Discrimination in Employment Act of 1967 protects people who are 40 years or older from discrimination because of age. Title I of the Americans with Disabilities Act of 1990, or ADA, makes it illegal to discriminate against a qualified person with a disability in the private sector and in state and local governments. The law also requires that employers reasonably accommodate the known physical or mental limitations of an otherwise qualified individual who is an applicant or an employee, unless doing so would impose an undue hardship on the operation of the employer's business. Federal contractors and subcontractors must take affirmative action to recruit and advance qualified minorities, women, persons with disabilities, and other covered veterans. Affirmative action includes training programs, outreach efforts, and other positive steps. These procedures should be incorporated into the company's written personnel policies. Employers with written affirmative action programs must implement them, keep them on file, and update them annually. Affirmative action requirements are administered by the U.S. Department of Labor, Office of Federal Contract Compliance. The Family Medical Leave Act, or FMLA, entitles eligible employees to take unpaid, job-protected leave for specified family and medical reasons with continuation of group health insurance. Eligible employees are entitled to 12 work weeks of leave in a 12-month period for a number of situations, including childbirth, adoption, illness, and other family medical issues. Sexual harassment consists of unwanted sexual attention that creates an adverse work environment. Sexual harassment includes intimidation, bullying, or coercion of a sexual nature, or the unwelcome or inappropriate promise of rewards in exchange for sexual favors. As defined by the EEOC, it is unlawful to harass a person, an applicant, or an employee because of that person's sex. Harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal and physical harassment of a sexual nature. There are two types of sexual harassment. Quid pro quo harassment is the most common. It occurs when job benefits, including employment promotion, salary increases, shift or work assignments, performance expectations, and other conditions of employment, are made contingent on the provision of sexual favors, usually to an employer, supervisor, or agent of the employer who has the authority to make decisions about employment actions. This form of harassment is often prohibited as a matter of criminal law, labeled the abuse of power, and is a form of sexual discrimination and a violation of labor or tort law. The second type of harassment is a hostile work environment, where employees in a workplace are subject to a pattern of exposure to unwanted sexual behavior from persons other than the employee's direct supervisor, where supervisors or managers take no steps to discourage or discontinue this behavior. Sexual harassment is a serious issue in both public and private sector organizations, with more than 12,000 complaints filed annually with the EEOC. More than 15% of complaints were made by males. Settlements, in some of these cases, include a substantial cost to the companies in terms of litigation. It's now estimated that sexual harassment is the single largest financial risk facing companies today. In this video, we reviewed a number of employment laws. Many of these laws are related to employment discrimination and are administered by the Equal Employment Opportunity Commission. We talked about Title VII of the Civil Rights Act of 1964, the Pregnancy and Discrimination Act, the Equal Pay Act of 1963, the Age and Discrimination in Employment Act of 1967, and the Americans with Disabilities Act of 1990. The EEOC also investigates complaints of sexual harassment, which includes any unwanted sexual attention.